in court.
Good morning, everybody. Thank you very much. Please be seated. And please call the case.
Good morning, Your Honors. The matter before the court today is the case entitled Aaron Hill versus Agri-Mark, Inc., case number 24 AP 123. Representing the appellant, Aaron Hill, is Christopher McVeigh. Representing the appellee, Agri-Mark, Inc., is David Greeby.
Thanks very much. Counsel, come on up, if you would, please. And before you start, for the record, introduce yourself and identify your client.
Sure. Thank you, Your Honor.
Thank you.
May it please the court. Good morning. My name is Chris McVeigh, and I represent Aaron Hill in this appeal from the Vermont Department of Labor's April 1st, 2024 decision.
Thank you.
I am here today to ask that the court reverse the Department of Labor's decision as it is contrary to the policymaking role that the legislature assumes and that the Department of Labor does not have, and that the court find that Rule 8.1500 is an invalid exercise of the department's rulemaking authority because it exceeds the statutory limitations imposed by Section 650A in Vermont's Workers' Compensation Act.
Mr.
Counsel.
McVeigh?
Yes.
Go ahead.
Thank you, Justice. Mr. McVeigh, is 650A ambiguous as how to evaluate concurrent employment?
650A1 sets out the general parameters for calculating average weekly wage for an injured worker. Section 650A1A4 involves the concurrent employment aspect of it. And contrary to the department's claim in its opinion that there's no guiding principle here in Section 650 for evaluating average weekly wage, Section 650 actually sets out multiple guiding principles. First, that the wages earned during a 26-week period, and the operative word here is during, and that is an ongoing, it's an active verb, and it denotes a specific period of time. Whereas the rule adds on language that only includes concurrent employments if they're in existence at the time of injury or at the time of disability. So that is a significant narrowing of what the legislature determined was the appropriate period of time for calculating all earnings within within that 26-week period of time. So the concurrent employment is basically part of calculating average weekly wage because, especially these days, lots of people have more than one job in order to make.
Can I pick up on that,
Oh,
Counsel?
sure.
At the time of disability, how many employers did this gentleman have?
At the time of disability, one.
Okay, so how is there concurrent employment?
It's concurrent because it happens during that 26-week period of time, Your Honor.
Well, is that right?
It is right.
Okay, under 650A, doesn't it say is employed?
No, 650A that's actually in Section 650A4.
Yes.
Okay. But the department recognized that is language that can go both ways. And if we're using a liberal interpretation of a remedial statute, which the Workers' Compensation Act is, it should go to the benefit of the injured worker. And does not eliminate that 26-week period of time. The basic framework is what happens during this 26-week period of time. The otherwise, and Mr. Hill's facts are pretty illustrative here because you can have absurd results where someone could be in a concurrent employment, work for 25 weeks up to 26-week period of time, be fired, maybe even for good cause, and that 25 weeks would not be included in a calculation of average weekly wage.
How do you distinguish Orvis versus Hutchins, which said that the purpose of workers' compensation is to compensate an individual for wages lost during the recuperation period? That's the purpose of these statutes. And he's not losing any wages from his former employment during his recuperation period.
So, Your Honor, Orvis actually deals with, I believe, earning capacity. as does Hoteling, talks about earning capacity as opposed to actually wages earned. And then the case I cited from the department, M&M versus Common Confectionery, focuses on earning capacity.
But
And so,
I understand that the facts might be different, but isn't the policy the same for this case and Orvis? That it's workers' comp is to replace wages someone won't get because they're recuperating.
it is, yes, the answer is yes. That is the goal of the Workers' Compensation Act. But it is not confined to the age or the wages that you were earning exactly on the date of disability, because you can have a situation where, and I think I referred to this in a brief, someone could have a intermittent employment.
A what appointment?
Intermittent employment, that they're hired to show up at the movie theater once every month for 6 months. And they have those, maybe 6 weeks, 6 days, because it's once a month of earnings. That person, because they still have this ongoing employment, their wages would be included. But someone who worked 25 weeks in 7 or 6 days and was fired on the day before the injury either became a disability or the injury occurred, they would be out for the concurrent employment. And that undermines completely the wage replacement goal of a liberal remedial statute like the Workers' Compensation Act.
But these wages wouldn't have been earned if he hadn't been disabled either. He would not have had these wages that we're talking about.
You're right. That's where it gets to earning capacity. The Workers' Compensation Act, as structured, is not so tight that you have to be in the employment on the day of injury. You have to be in an employment, certainly on the day of injury, but not in the concurrent employment. The net is spread widely here. It's not a narrow focus. And that's the problem with Rule 8.1500. It narrowed the focus of what is otherwise a broad net. And the structure of Section 650 actually shows that the legislature was intending to, it's not to maximize benefits, but it eliminates certain things that, like being out sick for a certain period of time during the 26 weeks. Those weeks are not included in calculating average weekly wage. If you, during that time, are in employment where your wages are increased, the weeks before that wage increase are not included. So the structure of the statute is looking to get a realistic sense of this individual's earnings. And it goes to earning capacity. It's not just earnings, but it's earning capacity. And Mr. Hill demonstrated that he had a significantly greater earning capacity than earnings that he had just at the Blackback Tavern, which he worked at from July through October. And so,
but was not working at the time of disability. He was not working there at the time when he had the disability. So he had three employments. The injury occurred outside the 26-week window, correct?
correct.
And the disability occurred while he was employed by one entity, correct?
That's true.
And so where does the middle employer, the one that was in the middle, how do you factor that in as to putting him in the same position when he chose not to be employed at the middle job?
Because that the earnings falls within 26 weeks. That's why. I mean, someone can earn a bonus during that 26-week period of time. One-time bonus, never going to happen again. That bonus is factored into the calculation for an average weekly wage. And so the legislature made the policy choice to include all earnings during that period of time. The legislature could have said, in the language of Section 650, all earnings, if you're in this employment, in the concurrent employment at the time of injury. And they don't include disability. The department included the language disability. I'm sorry.
You just referenced the language of the concurrent employment under the WCA. That was added in 1965. What's the intent behind adding that language of the concurrent employment?
I think you're referring to the Quinn versus Pay case, where this court did not aggregate concurrent employment.
I'm referring to the legislature's addition of concurrent employment into the WCA. That provision was added in 1965, and I cannot find what the intent was behind adding that provision. Do you?
I don't know the intent, but my inference of the intent is that you're taking into account all the earnings that an employee had earned during the 26-week period of time. Then it was 12 weeks, but it was expanded to 26 weeks. But in Quinn versus Pate, this court did not aggregate concurrent employments because the statute didn't indicate that they should be aggregated. That was changed. Now you do include all of the concurrent employments in calculating average weekly wage. And the legislature very clearly put 26 weeks. Didn't make any exception for saying you had to be in the concurrent employment at the time of injury or, as the department included, disability. And so I think the rule undermines that.
We look at whether a provision is more specific than a general provision. And even though there's the 26-week look back, wouldn't you say that 650A4 is the more specific provision with respect to concurrent wages?
I think section 650A4 is incorporating concurrent employments. And the is language there is referring to the 26 weeks. The FLEs make the point of saying that 26 weeks is not included in A4, and they're right on that, but can't be read any other way. Is it concurrent employment only during the first week? Is it only during the last week? I mean, it's during the 26 weeks is the dominant time frame for calculating average weekly wage. And I don't think there's any reason why it would not apply to concurrent employment as well. I see my light is going off. I have to reserve some time, so I have to part now.
Yeah. Okay.
Thank you.
Thank you. We'll hear from counsel for the appellee, please. And before you start, if you would, introduce yourself and identify your client.
Good morning. May it please the court. David Greeby on behalf of the appellees, Agri-Mark Incorporated.
Thank you.
What we have here is a case which ultimately rests on the principle of agency deference. The application of the provisions of the Workers' Compensation Act are entitled to substantial deference, and the decisions of the Department of Labor are presumed to be correct and reasonable unless there is a clear evidence to the contrary or evidence of error.
There is a difference, if I can put it that way, between the rule and the statute. Is there not?
Your Honor, I would say that only in the actual language, but I don't believe in any of the meaning or what could be the interpretation of the statute.
Well, okay, just hang on there, though. There's a difference between what it is that the rule actually says, which is, I think, more specific than the statute. Would that be fair?
Your Honor, I think that I have to concede that the rule has language of at the time of disability or injury,
Right.
Whereas the statute does not. But in order to make a determination on
So before you continue, I'm sorry to keep interrupting you, but give me the case that you say gives the department the flexibility to adopt more specific language than what the statute provides for. What case do you rely upon for that?
Your Honor, I think that in order to get into that analysis, it's incumbent to look first at the authority of an administrative agency to make rules and the deference that should be given to them because of their expertise.
Give me a citation, would you?
Yes. So, Your Honor,
I've got a bunch of cases in my notes. I just don't know which one.
Yes. Yeah, Miller versus IBM, Your Honor. Administrative rules have a presumption of validity and are valid if they are reasonably related to the purpose of the enabling act.
Does it say anything about being more specific than the act itself?
Your Honor, I believe this court in the Shire's housing case indicated that where a statute is silent and ambiguous, and an agency charged with enforcing the statute has interpreted it, the court will defer to the agency interpretation of the statute.
Does it say anything about this issue of more specificity than the statute?
Your Honor, I do not have a cite referring specifically as to.
If you go outside the jurisdiction, have you got a cite for that?
I do not, Your Honor, at this time have a cite as to.
And we've never addressed it, obviously. I mean, you wouldn't be here if we had.
Yes, Your Honor, but if
I mean, I assume it states the obvious. You know, I've got a bunch of cases here in my notes, but so far I don't have any of the ones that you've mentioned. So I can look at them.
Again, Your Honor, I think that what's important in the circumstances and the facts before the court in this appeal related to a concurrent employment, Section 650 is what's at play, and that's what the Department of Labor was interpreting when they made Rule 8.1500.
Right.
Now, as Justice Eaton pointed out, I believe that the language of 650 in and of itself indicates that an injured worker would have to be employed at the time of injury or disability. Because of the language in A4, the present language is employed. Now, at the lower level, the Department of Labor disagreed with that and opined that that's merely one of two potential interpretations of that language, meaning it either is or was. I would disagree with that. And I believe that 650 is clear that concurrent employment, that in order for concurrent employment to be counted towards someone's average weekly wage, they have to actually be employed. But if we were to just take a step back for a moment, it's imperative that we look at the intent of what average weekly wage or temporary total disability benefits are for. We find that under Section 642. The purpose, this court has found on multiple occasions, but there's no question that the purpose of disability benefits in a workers' compensation claim is to provide someone a partial substitute for their wages during a period where they're in recuperation.
So would there be any question whatsoever had the applicant been employed by 2, 3, or 4 different employers at the time of the disability, regardless of when the injury occurred? When the disability comes in and he's out on total disability, that those would be calculated as part of his compensation?
No, Your Honor, I don't think there would be any dispute, because if someone is actively employed with an employer and receiving wages, regardless of how they're receiving those wages in the timeline of those 26 weeks, that would be included. Appellant raised a hypothetical in his brief, and also again today in front of the court, that we have a circumstance where someone's working 1 day a week, only 8 hours every 4 months, and that's included. But yet the appellant, Mr. Hill, his wages are somehow not included. Well, what's important to remember is that Mr. Hill voluntarily resigned his employment from Meeting House. So he was no longer an employee at the time of disability. So wages are paid to employees for their remuneration of services, and he was no longer an employee. So if there's no active employment, there's no wages to replace.
Is there any question about his termination from restoration that had anything to do with the hernia injury from his previous employer, from Cabot?
In this appeal, Your Honor, there's no dispute that Mr. Hill voluntarily resigned, and there's no contention, nor is there any evidence for the court that it was related in any way to his disability for purposes of going out in the hernia surgery. Now, if he had been employed at the time, or perhaps a medical doctor may have provided evidence that he would have needed to go out, then perhaps we would have a different circumstance where there'd be a better argument that would then be included. But in this case, there's no evidence to that.
So if he couldn't, because of the injury that occurred at Cabot, he was no longer able to do the work at restoration because of that injury, that would be a different analysis than we're talking about today.
It would be a different analysis, Your Honor. I'm certainly not saying that it would. It would depend on a factual basis of that employment severance. But I think that, again,
So counsel, I asked Mr. McVeigh, so Mr. Greeby, did I pronounce that correctly?
Greeby, yes, Your Honor, thank you.
You're welcome. Mr. Greeby, people always mispronounce my name too, so I'm sensitive to that. Mr. Greeby, can you tell me what you think is the intent behind the inclusion of the concurrent employment language?
Yeah, I think the intent is obvious. I think it's common sense, as I pointed out in my brief, that the intent of that is to provide for a partial substitute of an employee's wages when they're not able to work because of a work injury. If someone is working 2 jobs or 3 jobs or 4 jobs, as counsel pointed out, like many people do these days, then the injury is hurting their wages that they're no longer able to get while they're recuperating. There has to be some limit.
So let me follow up on that. So the language under 650 seems to encourage, in my mind, and if I'm wrong, please tell me, a preference for a higher rate of compensation. And should that influence me in terms of what is the intent?
I think what we need to focus on is the intent of having disability benefits, which would then.
But it's a remedial act, right? I mean, in the law it's clear, I think, tell me otherwise, that we construe a language in statutes of such kind in a liberal way.
It is a remedial statute, Your Honor, and I think that what Her Honor was referring to is 650A7, which allows for if someone has a higher weekly wage within that 26 period within their employment, then only the higher weekly wage should count. And I think that makes sense, and it's a good protection against injured workers, because if someone gets a raise, throughout the course of their employment and then gets injured, they should be getting paid at that raise rate that they got, and it should not include the weeks prior to that raise.
What do you say about Mr. McVeigh's example of an employee getting a one-time bonus during this period of time? From your point of view, is that included under the language of the law?
Your Honor, bonuses, there is a bit of nuance, I believe, to whether or not bonuses are included, depending on whether or not they include like a profit sharing or a bonus. But if someone gets a bonus, that is a wage. That is something that they're getting paid. But in the circumstance, what's different about the case that we have here today is that Mr. Hill was not currently employed with Meeting House anymore. He wasn't receiving any wages.
His example was a bonus, not at the time, just a bonus during that period of time.
Yes, Your Honor, could I ask the court to be a bit more specific on the question?
It's his example, not mine. We'll find out when he gets back.
Can I ask a question? I'm looking at the language here in 650A4. It says if the injured employee is employed in the concurrent service of more than one insured employer, blah, blah, blah. Doesn't is employed in concurrent service mean there has to be more than one? How can you have concurrent employment if you're only working for one person?
I absolutely agree, Your Honor, and that's the point that I brought up both in the department and the brief, and I touched on it earlier today. I think that language is clear. I don't think that 650A4 is inconsistent, nor is it even ambiguous, because if we look at the intention and the clear language of 642, which is the purpose of allowing for disability benefits, there's, I think, only one outcome that any judge could come to, and that is that concurrent employment must have. I'm sorry, Your Honor.
No, I like the language. I'm just complimenting you on your language. And that any judge can come to. I mean, except for that, you guys are here and you've got 5 judges in front of you. I appreciate your point of view, counsel. I'm not making, believe me, I'm not trying to.
I understand, Your Honor.
Yeah.
I also, interesting enough, the case was brought up by opposing counsel of Comet Confectionery. And the court was looking in that case as to past and past earnings. And council's using that as a way to argue that it really should all be about earnings, but it's not. It's about replacing your wages that you're actually receiving.
Well, I think his argument is it should be about earning capacity. And so, which is a slightly different notion than earnings. Which gets back to this, what I thought I understood until you asked me the question about the bonus, the one-time bonus, not, at a specific time, that the rule, would relate to. So, anyway.
Yes, and my point in bringing up the Comet case is that the ruling in the Comet case actually opined that to award replacement benefits when the disability was due to reasons other than work would have amounted to an undeserved windfall, one inconsistent with the statute's intent. That's essentially what we would have here if the court were to find in favor of the appellant. Counsel used his hypothetical, but a contrary hypothetical would be that, say someone is an extremely high wage earner and almost 6 months before, so for 3 or 4 weeks before, 3 or 4 weeks in the beginning of, say, we'll call it that 26-week look-back period, they're making $1 million a year. Now, of course, there's a statutory cap as to what the maximum compensation rate would be. That person retires, okay? Months later, they work for 1 week and they're working the job within the hypothetical, where someone's working, appellant's hypothetical, makes $120 a week. They're only hired to work 8 hours out of a 4-month period. Counsel's argument, or the appellant's argument, is that the entire 26 weeks should be included in that. So if the person who retires, who's a very high wage earner, doesn't work for a couple months, then goes and works making $100 a week, then the new employer, if that person is injured on the job, the new employer is responsible for paying an average weekly wage that would include a maximum compensation rate. That is the definition of an undeserved windfall, I think. And that's what confectionery was also pointing out.
Mr. Greba, before we run out of time, just a question involving rulemaking that the department has. And is there any question in your mind about that the department does have the ability? You're right, I'm sorry, we're out of time, but that the department does have rulemaking authority?
Yes, Your Honor. They have rulemaking authority through 21 VSA 602. It allows for them, so long as they're not inconsistent with the provisions of the statute, in this case, the Workers' Compensation Act 650, I think it's clear that they're not, that Rule 8-1500 is not inconsistent in any way with 650. I think that 650A4 clearly indicates that there needs to be active employment. That coincides with the purpose of 642, which is that average or temporary disability benefits are a wage replacement, and you cannot replace wages that no longer exist. I think it's important to remember that 650 is just merely the computation of the average weekly wage. It is not the entitlement to disability benefits. That is under 642.
Okay.
I think I'm out of time.
Yep.
Thank you.
Thanks very much. How much time is the appellant have, please?
Appellant has 3 minutes, 37 seconds remaining.
All right, counsel.
3 minutes, 37 seconds.
Thank you. A couple points. Section 650 is designed to calculate average weekly wage. Section 642 deals with temporary total disability benefits, but the average weekly wage is used for calculating not only temporary total when someone's totally disabled from work, but permanent and partial impairment benefits, entitlement to vocational rehabilitation benefits. And so someone, there's the Wheeler case that this court decided, can have an injury, never go out of work, and still need the average weekly wage calculated. And so it's not only for temporary disability benefits. You know, in the Wheeler case, that individual continued to work, never lost a wage, but the average weekly wage is calculated for more than one purpose under the Act. What we're dealing with here is a policy decision. The legislature policy decision was to include earnings during, and during is an active verb. It's during 26 weeks. They prepared the 26-week calculus for calculating average weekly wage, and they gave the parameters. It's not up to the Department of Labor alone. The department, in their decision, said, there's no guidelines, we have to decide it on our own. That's not correct. There are multiple guidelines within Section 650.
If we find that that language is employed under the statute, means you have to be employed at the time of the injury, is the rule consistent with that? If we found that, would we then find that the rule is consistent?
Your Honor, if you found that, then I would say the rule would be consistent.
Would
But the
what?
rule,
I'm sorry.
I said if you found that, I would say the rule would be consistent. I don't think you should find that because I think that is inconsistent with the broader scope of Section 650A1, which is talking about the earnings during the 26-week period of time.
Do you know when the rule was promulgated?
You know, I don't know.
I'm wondering, the legislature had some time to amend its statute if it didn't like the rule.
It's been, to be blunt, it's been in existence for a long time. I don't think it's ever been challenged before, but you always have time to right or wrong. Time, no statute of limitations on righting or wrong.
Yeah, as the chief says, any judge could do that, right?
Well, 3 of you.
All right.
Anyway, we're talking, so we have a policy dispute here. And I don't think there's any dispute that Rule 8.15 narrows Section 650. It does, because it eliminates employments that would otherwise be included, including Mr. Hill's.
Under your reading of 650.
I'm sorry?
Under your reading of 650, it narrows it. If we say
What other
is,
reading is there, Your
we
Honor?
say is means is, then.
No, right, under our, right. But I think if you take 650 at its face value, it says during 26 weeks. And I don't think Section 4 subverts that. I mean, Section 4 does use the active verb is employed. But the department itself said that could be read both ways. And under a liberal interpretation, you would read it the way to provide greater coverage.
So doesn't that mean it's ambiguous? I'm sorry, Mr. Chief Justice, I think it's like this one on, but
Oh, no, go ahead, please.
thank you. It can be read to both ways. Does that mean it's ambiguous?
See, I don't think it's I don't think Section 650 is ambiguous. We're talking about Section A4. And if it can be read both ways, the liberal interpretation would favor an expanded coverage rather than a narrowed coverage. Thank you.
Okay, thanks very much. Please call a conclusion of the hearing.
The next hearing for the court is